This was a big deal because showerheads have been really bad for many years. We're not talking about tariffs. This is an amazing thing. Whether you're a Democrat or a Republican, you should love this executive order because we all now get to have a proper shower. Welcome to Silberman Law Firm's Weekly Docket, where we talk legal news and practical law. My name is Phil Silberman, owner of the firm and your host. Today is April 10th, 2025, and I'm joined by my co-host, Austin Black. How are you doing today, Mr. Black?
I am doing great.
I'm doing phenomenal. I understand you had a trial today, Phil, or yesterday. You had a trial yesterday, right?
Yeah. Yesterday, yeah. I feel pretty good about it. It's one of those ones where the judge said she was going to rule soon. My clients came out, wait, does that mean she's ruling? Does that mean we'll get like something tomorrow? I was like, if the judge gives a specific timeline for a ruling, if they say, I'll give you my ruling in 2 weeks, that usually means in a month. If they don't give a specific timeline and just say like vague, like soon, I probably might not even expect it for 3 months. We'll see.
That's a good point for our listeners. I think a lot of people believe that when they go do a trial, especially a bench trial, the judge is going to give them an immediate decision.
Yeah.
That is certainly more rare than normal. That almost never happens. Usually the judge will
Sometimes they do, but yeah, it's rare.
It's rare for certain. So
sometimes they do.
We've had some, Austin, where we've done the whole trial, waited for a month and 2 months and 3 months, and we call the court coordinator and we say, hey, when's the judge going to rule on this? Maybe just politely ask the judge to rule. And the judge just would not rule. We've had some of those. And I saw one attorney, and in Texas, we file a lot of made up motions. That doesn't always work in federal court, but it was a motion of like, motion for judge to enter ruling. It's been a long time.
Yeah.
And you just go in front of the judge. You're like, hey, judge, what's up? Why can't I get this ruling? And I think that for that case, the judge actually said, I'm in a really bad mood. You don't want me to do this today. And we just went home and we waited. Yeah, that's how that goes sometimes.
We talked a lot about impeaching judges recently from some political parties. This is a legitimate reason to impeach a judge. Okay,
a judge is a civil servant. In Texas, they are elected. So we do want something from them as far as doing their job, but they are the judge. So you don't want to upset them. So there's always that tightrope that you walk in. But so normally I ask you, Austin, what's on our docket today, but I'm going to go ahead and take this one because the docket is pretty simple. There's one thing that caught my attention as far as like a news piece, and that's all about showerheads. So we'll talk a little bit about showerheads, and then we just really need to knock out a bunch of random legal questions in this show because we have not done that in a long time.
I can add on showerheads, by the way.
Okay, great. You're going to have that opportunity in just a moment. So we're going to talk showerheads.
I might even be showering you with them.
Yeah, we're going to talk showerheads, then we're going to answer legal questions, and then we're going to close it out. So let's go ahead and get it kicked off with our legal news section, which consists of one piece here. And we're talking about showerheads. President Trump signed an executive order saying that we no longer have to use the old definition of showerheads as defined by Barack Obama and Joe Biden's administration. We now get to go back to the 1992 definition of showerheads. And Austin, this was a big deal because showerheads have been really bad for many years. So we're not talking about tariffs. But we're going to talk about shower. This is an amazing thing. Whether you're a Democrat or a Republican, you should love this executive order because we all now get to have a proper shower.
That's great. What's the difference?
Okay. How's the shower in your apartment? Do you feel like you get good enough water pressure in your apartment?
Yeah, it's fine. It's not bad, not the worst.
Okay. So it's like when you don't know anything better, right? If you've never actually been on a yacht in the Mediterranean, you don't know how amazing that is, right? So you probably don't know how amazing it is to take a proper shower is what
I'm going to push back a little bit because I've been in some very high quality establishments, like mostly abroad, right? In Japan, they have very good shower heads. Very, very good shower head.
Okay. Let me give our listeners just a little history on this.
Okay.
A normal shower head back in the olden days when I was a kid would put off, I've got that 2.5 gallons per minute. Okay, that's a nice shower with great water pressure. And then all of a sudden, the Obama administration decided that was wasting too much water. So they decided to make this really complex definition of a shower head that's supposed to regulate or restrict the amount of water flow, right? And here's something that's interesting. Between the Obama administration and the Biden administration in the last 12 years, they came up with a 13,000 word definition for shower head.
Okay.
With the main goal. Now, keep in mind, the Oxford Dictionary manages to define showerhead in one sentence.
Okay.
But they came up with this very elaborate definition and the idea that it's going to restrict showerhead flow. So it's really, if you just go buy a showerhead at Home Depot, or if you go to an apartment complex that's been built recently, you're not getting a very good water pressure showerhead flow. In fact, it's rather frustrating. It was so bad that I'm a member of a tennis club. I play tennis. I take showers. And it got so bad that when we remodeled our locker room, we actually kept the old shower heads from the 1980s and put them in the brand new locker room so we could all get proper showers. If you haven't experienced this, you need to go after this executive order signed, wait a month or two, go buy yourself a proper shower head, screw it on in your apartment complex, and you're gonna be like, what have I been missing my entire life? That's what it's gonna be like.
Interesting. So I did actually have to buy a shower head in Korea because I think it was actually a shower head because the water there is in the shower specifically can do things to like your skin sometimes. And so we'll get like filters like with the little balls in them, you know what I'm talking about?
Yeah.
Like the charcoal filtered out. Yeah, people get those and they put them on all the shower heads. So yeah.
This environmental stuff is crazy, and you can talk. It's actually very appropriate to talk about being abroad because Europe is the prime example where the environmentalists have just gone whacked out crazy. So Europe has probably had all the showerhead stuff for many years. Also, people in Europe, it's like you don't really can't get a dryer. It's very unusual to have a dryer in Europe. And I lease lots of Airbnbs in Europe. And if you do get a dryer, it's this really underpowered dryer where the clothes come out down. So instead of just taking one cycle to dry your clothes, you just end up running the dryer like 5 times. That's not more energy efficient. And then I don't mean to be crass about this, but toilets in Europe are awful. And that's because they only allow a certain amount of water in the toilet because they want to be environmentally friendly. It's stupid because you end up having to flush the toilet 5 times. So what would have taken one flush, what would have taken one drying cycle ends up being much less energy efficient, all in the name of this craziness. So
in contrast to Japan, where they spend thousands of dollars on their toilets.
Yeah, now the Japanese go a little crazy on the toilet stuff, but good news, Trump has made shower heads great again. That's what he's done. And however you feel about Trump, I would disclose, I'm not like a huge Trump fan. And the tariff thing, even like my ultra conservative, like fiscally conservative, like hedge fund managing oil and gas tycoon friends, they were ready to like not vote. I was playing tennis with my brother yesterday, and my brother was like, I'm not voting for him again, Phil. I'm not voting for Republicans. He was so upset. And then the market was up like 12% yesterday. So it's down again today. But everybody can agree that this showerhead thing is going to be amazing. We're back to the 1992 definition of showerheads, everybody. So let's just rock that amazing victory for showerheads. Big news. Probably one of the most important executive orders that Trump has signed this term. I'm just going to go out on a limb and say that. All right, we got to get.
Someone's going to try to fight that one. You think they're going to ask for a TRO?
Yeah, I think we're going to get it. I think we're going to get a lawsuit and a TR saying that that's way beyond executive authority
from Big Showerhead.
Big showerheads, yeah, big showerheads. That's right. All right, look, we got to move on to our legal questions section now. We haven't done enough of this. Austin is doing this show without looking at any of the material. Is that right, Austin?
That's correct.
Okay, so this is just going to be dial a legal question or random legal question, stuff that has come into the law firm. We're not going to reveal any confidential information. There's no way that you could tell who this is asking these questions. And Austin, you're going to get just very short, just whatever they gave us. And we'll take turns. You're just going to opine on what they could possibly mean. And we'll just go from there. Okay. So first legal question or email that came into the firm is just simply estate planning. Estate planning, 2 words, no question. What is it? What do you think, based on all these calls that you've done, what do you think they need? What do they mean? What kind of estate planning do they think?
They probably just need a basic will. And then maybe in addition to that, a durable power of attorney.
Yeah. So regular people out there hear me on this, and we don't have a white glove practice, and I don't have any problem.
I don't even own any white gloves. Yeah.
I don't have any problem telling the listeners out there, we represent medium businesses, small businesses, individuals. And most of the people calling us up do not really need estate planning as people understand that to be. You just need a simple will, a couple of power of attorneys, medical power of attorney, statutory durable power of attorney. You don't need any complex trusts, most likely. The only time you really need estate planning, I would say, would be once you get into taxable estates, which I think if you're married, that's up around $23 million of estate value. Or if you're single, I think it's 10, 11, $12 million, whatever that threshold is. Once you get into these taxable estate ranges, you do need kind of complex estate planning. But if you're not going to have a taxable estate, you just really need a basic will, a couple of powers of attorney, or if you have some other special needs, if you've got predisposition to becoming incapacitated, or you've got some special needs children, you may need some estate planning there. But other than that, no. All right, next one, Austin. LLC business in Austin, Texas, that she might consider selling. What comes to mind?
Yeah. So usually in a business sale or an acquisition, what people are wanting to do is not a sale of the actual business, but just a sale of the assets of the business. That way, a lot of the liability concerns don't pass over with those documents. And then we also don't have to deal with doing due diligence that you normally have to do if you are acquiring a whole business, right? You'd need to do tax compliance, make sure you have an accountant look over the books of the business, things like that.
You're talking about the buyer side.
The buyer side. You don't necessarily need to do if you are just purchasing assets, but as a seller, it just makes the situation a lot easier for you.
Yeah. And for certain, you're less concerned about these due diligence concerns. If you're the buyer, you're very much concerned about due diligence. Austin's correctly pointing out, if you're a buyer out there, absolutely always do an asset acquisition. Try to avoid buying the actual business, because businesses come with contingent liabilities. They come with tax issues. They come with potential lawsuits. So always go out there, buy the assets, form a new single purpose entity, throw those assets into the single purpose entity. And then that's the best way to start operating as a buyer. In this case, it looks like the seller has an LLC considering selling. If you're the seller, you're not so concerned about the way the buyer is going to acquire the business, because you just want your money. But the way this typically works as a seller is it's going to be a little unusual for someone just to give you a completely cash deal for your business. That doesn't happen very often, unless you're like right now, Austin. What's really popular is if you own like a plumbing trade or an HVAC trade. All of this private equity money is coming in and buying those kinds of businesses and then rolling them up into one big kind of entity. And in those cases, that is going to be an all cash offer, but that's not typical. If you're a small business out there and you're selling, what most likely is going to happen is another buyer is going to come, also a small business buyer. They're going to have a little bit of cash. They're going to end up getting an SBA loan, Small Business Administration loan. And then you're probably going to end up having to do some seller financing as well. That's going to be subordinate to that SBA loan. So you're going to end up with an asset transfer agreement or a contract to actually sell the assets. You're going to end up with the SBA promissory note. You're going to end up with your subordinate loan promissory note. You're going to have two security agreements, and then you're going to have some financing statements. It's counterintuitive. The financing statement is actually a UCC-1 that gets filed with the Secretary of State. So those are your typical document sets. Now, if for whatever reason your buyer or your borrower defaults after you sold the business, if we do that transaction as your lawyer, we're going to have some stuff that can, through that security agreement, we're going to be able to hopefully come in and take possession of that business again so you can continue operating and not destroy the value. So some of the big things you're thinking about when you're selling a business. All right, next one. Eviction notice for a residential property in Austin, Texas. Again, but what comes to mind? Eviction notice. What is an eviction notice?
I am assuming if that is all they have in there, that they've received an eviction notice. I'm assuming that's probably what it is. Probably not the landlord reaching out to us.
Probably not. Yeah. So they probably got a notice to vacate.
They got a notice to vacate. Yeah.
Have you done evictions before?
Yeah.
Okay. Tell us a little bit about the general process of an eviction.
Yeah. For an eviction, if it is required, you need to review the lease first.
Yeah.
If there is one. And then if there is a lease, normally you need to send a notice to vacate if that hasn't already been sent, like why the lease is being terminated, things like that. And after the notice to vacate is passed, if they are not out, then you have to follow the process of actually filing for an eviction. You have to make sure that they aren't an active service member, so they're not getting kicked out or abroad or something like that. You need to ensure that they've been properly served with notice of any hearing that's been set up. And then you have to go to the eviction hearing, usually in JP court, and show the court that your client owns the property, and that usually it's for non-payment of rent. They haven't paid rent for a certain period of time. Typically you ask for back rent, but sometimes you don't. You just ask for a writ of possession, giving you possession of the property. And then if the judge issues a writ of possession, the constable will go out and actually execute on that writ of possession, forcibly evicting the person from the property and giving you possession.
Yeah, that's a pretty good summary. Austin is saying, hey, this person calling in, emailing in, whatever, probably received a notice to vacate.
Yep.
So before you file an eviction petition in Texas, you have to give the tenant a notice to vacate 3 days before filing.
Yep.
Once you give that notice to vacate, can be through regular mail, certified mail, however you want to do it. Then you can file that eviction petition. We used to call that a forcible detainer lawsuit. Now we've just simplified it. Call it an eviction petition. You got to make sure the person is not in the military. And then you file that with the court. You go down, you have the hearing, a little eviction trial. You typically give the lease to the judge. You give the ledger showing an outstanding balance if it's a non-payment of rent eviction. And then you ask the judge for a ruling. Typically, you're looking to get possession and back rent, and hopefully get your ruling. Tenant has 5 days to appeal that. If the tenant does not appeal, then you hope they get out. If they don't get out, you can ask the court to issue a writ of possession that goes over to the constable. The constable will then execute that writ, do a set out if necessary, where that constable actually comes and physically removes them. And then you have to call a mover and a locksmith in that situation. And that's how you get possession of your property. By the way, Austin, if you do get a judgment for back rent, you're almost never
able to collect on it.
Yeah, it's just so hard to collect.
Yeah.
All right, Austin, you go ahead and read me this next one, and I'll take a stab.
He is in the process of buying a property in Texas. He and the seller and realtor have agreed to have a contract that everything on the property, including some additional, personal property, should be in the closing. They agreed the closing should be the 31st of last month. They're not signing or pushing the date of the closing to get more stuff out of the property, which is not what they agreed.
Okay. So you actually have two independent issues there, which are interesting. The first issue, and this comes up a lot when you're buying residential property, is personal property. So you buy the real estate, but then the contract's also going to envision sometimes some personal property coming with the transaction. And you can't just lump the personal property and the real estate all in the same contract. Even though legally you can. The reason we don't is because the lenders don't like it. The lenders loaning money on a residential loan, they don't want a loan on personal. And the general rule is if the thing is bolted down like a dishwasher, that's a fixture that's part of the real estate. But oftentimes you'll see a washer and dryer that needs to come with the property, and that's not a fixture. Okay. It's just plugged in.
Yeah.
So you got to figure out, okay, a refrigerator, a washer, dryer, whatever else that's personal property that you may want as a buyer, you need to specify that. And you typically do that in an addendum or an independent contract. The most popular one that the realtors use is called a non-realty items addendum. The last time I checked, and you just give some like nominal consideration, like $1 for your washer and dryer. And
I always just put $10. Yeah.
Yeah. And that's how you get the personal property to come over with the sale. All right. The next thing he's pointing out, and this one's interesting too, is the closing date keeps getting pushed, right? Talk a little bit about that. Does the term time is of the essence mean anything to you, Austin?
If I said no, I have a problem. Yeah, time is of the essence does mean something to me.
Just tell the listeners what that means as a lawyer.
Yeah, it's a pretty important provision in any contract, honestly, not just a realty contract. But in the context of real estate, typically, if there's a closing date set in that contract to purchase, not meeting the closing date is not a material breach of the contract. People understand that stuff happens. You can either delay from title company or any other reason. There could be a delay in actually when you can close on the transaction. And normally, again, that's not a material breach. So if someone missed that, you couldn't sue them and say, you breached the contract. But in the situation where it says time is of the essence, specifically with that language, then if you miss the closing date, that is a material breach for whatever.
Yeah, absolutely. And I think what the listeners, people need to understand is the courts have recognized this phrase, time is of the essence, to mean if you put that in a contract, any contract in Texas, that means if there's a date, we expect you to meet that date. And if you don't meet that date, then you've breached the contract.
Yeah.
That's a time is of the essence contract. Now, Austin's pointing out that our standard TREC form, our Texas Real Estate Commission form for buying and selling residential properties specifically does not have a time is of the essence provision in it for the closing date. If we did, no deals would ever close. There'd always be a breach because lenders all the time are dragging their feet. Title companies are taking a while. You would never get anything closed. That's why we don't have a time is of the essence as it applies to a closing date. But Austin, at some point, let's say at some point you do have to close. And what if this thing is taking like a month or 2 months or 3 months? What do you think? Like, when does a breach?
Whenever a time that is not reasonable has passed in the judge's discretion, who's looking at something. Yes.
So that's the courts have, you're pretty close. The courts have, there's been some cases out there. The courts have basically said at some point, we think it's 3, 4, 5, 6 weeks. It's somewhere like in that range. We've got some appellate court decisions out there that are saying at some point in that 4th, 5th, 6th weeks, there is a breach. Okay.
Got it.
The buyer doesn't have to wait forever. It's also the builders do the same thing. You'll sign a builder contract, and the builder contract will just have nothing. Like the builder could take forever to build it. And when we get those disputes, we often get people calling us and they're saying, the poor buyer is like, this thing was supposed to be done in July of last year, and now it's July of this year, and I'm waiting on my house. And my contract, I was so dumb when I signed the contract. It doesn't say the builder has any certain amount of time he has to build this thing. And that's where I usually say, look, at some point, the builder actually has to build you a house, even though it's not a time is of the essence contract. Now, final thing I want to point out here is the option period. There are other periods in the TREC standard contract that is time is of the essence. The option fee period is time is of the essence.
Absolutely.
Okay? So if you
miss dealing with that right now.
Right. Yeah. So
you missed that, it's on you.
Yeah. If you've got a 10-day option period and you don't terminate by 5 p.m. on that 10th day, then it's strict. You don't get you're done. Okay. You're hard on the contract. So there are certain dates in that TREC contract that is time of the essence. All right. Final one here, Austin. She needs a power of attorney so she can be over with her dad. You'll hear that phrase a lot from people. I need to be over my dad. That's a colloquialism.
Over with? They're
Yeah.
dead. That's an odd phrasing. I don't know exactly what that means. I don't know if she's like thinking the power of attorney is going to give her authority to like come out of there or what. But if we're going to try to parse the meaning of this, right, it probably means that she thinks her father, for some reason, is making bad decisions. She wants to stop him from making bad decisions. So then we go down two branching pathways, right? Does her father have legal capacity? Can he legally make decisions? Is he of sound mind, etc.? If so, then sorry, you're out of luck. There's no way you're going to get power of attorney over him unless he's signed it over to you in his right state of mind. Or he is not of the right state of mind. Say he has Alzheimer's. At that point, then you don't need the power of attorney because he doesn't have capacity to sign that power of attorney over to you because he can't sign contracts. You would need a guardianship, and that's a much more complex process than just someone signing over power of attorney.
Yeah, Austin's 100% correct. If dad's in a good state of mind, he knows what's going on, and dad wants to voluntarily sign powers of attorney over to daughter, that's easy peasy lemon squeezy. Okay. You just do a statutory durable power of attorney for the financial stuff. Your dad can do everything, check all the boxes, if you will. And then she'll have power over real estate, over stocks, over money, bank accounts, whatever. That's easy. And then if dad wants to give her a medical power of attorney to make decisions for dad's health, then that can be done simply as well. Note that if dad still has capacity, okay, dad can make decisions and the agent, the daughter in the situation, can make decisions as well. Dad can revoke the power as long as dad is in sound mind. Dad can revoke the power of attorney at any time. Dad can appoint other powers of attorney. If dad does not have capacity, then dad cannot at that time, as Austin pointed out, dad cannot at that time sign over a power of attorney because he doesn't have capacity to do. And then you'd have to seek the guardianship, which is a more time-consuming and expensive process. All that is good stuff. And we knocked out, I think, 5 or 6 of those questions. We did good work today, Austin.
Good.
So
good.
That brings our show to a close. I've been your host, Phil Silberman. Austin Black has been my co-host. Like us, follow us, review us wherever you get your podcasts. As a reminder, nothing in this show is to be considered legal advice. This has all been for entertainment purposes only. If you do have a legal question and you want us to answer it, email us at info@silblawfirm.com. That's SILB, like boy, lawfirm.com. Tell us you want it answered publicly in the podcast. We will do our best. So everybody have a great rest of your week and weekend.
All right. Thanks so much, guys. Bye.